Welcome to The Explainer. Today, we are going to map out the entire journey of a civil lawsuit. Now, this whole process can seem super complicated, maybe even a little scary. But don't worry. By the end of this, you're going to have a clear roadmap of how it all works, right from that first moment of disagreement all the way to the court's final decision. You know, we've all seen those intense courtroom dramas on TV, right? But the reality, well, it's a lot more methodical. It's not really about those last-minute surprise witnesses or dramatic confessions. It's actually a very structured process, kind of like a legal chessboard, where every single move is carefully planned and has to follow a strict set of rules. And it's all designed to make sure things are as fair as possible. So how does this whole journey play out? Well, we can break it down into 4 main stages. First up, we'll look at how a lawsuit even gets off the ground. Then, we'll see how the two sides draw their battle lines on paper. After that, we'll step into the courtroom for the trial itself. And finally, we'll get into the verdict and everything that happens after the judge makes a call. Okay, so every single lawsuit kicks off with one absolutely critical document. You can think of it as the opening shot, the formal start to the whole legal fight. It's called the plaint, and it's the piece of paper that officially gets the wheels of justice turning.
So, what exactly is a plaint? Well, it's the official paperwork filed by the person who's starting the lawsuit. We call them the plaintiff. This document is basically their formal complaint. It tells their side of the story, what went wrong, and it's what they hand to the court to get the whole process started.
And believe me, this isn't just a simple letter. A plaint is incredibly detailed. It's got to clearly name everyone involved, lay out the entire story of what happened, prove you're filing in the right courthouse, and state exactly what you want the court to do about it, the specific remedy you're looking for.
Now, here's a really crucial point. A court doesn't just automatically accept every plaint that comes its way. If you happen to file in the wrong court, that's a relatively easy fix. It gets returned and you just refile it in the right place. But if the plaint itself is legally flawed, like if it doesn't even state a real legal reason to sue, it can be flat out rejected. This is the court's first line of defense to filter out cases that just don't have a legal leg to stand on.
So once the court gives the plaintiff the green light, it issues something called a summons. This is the official legal notice that goes to the defendant. It's that formal "you've been served" moment you see in movies, and it legally requires them to show up and respond to the lawsuit. And this is exactly why a summons is so serious. If a defendant just decides to ignore it, the case doesn't just magically disappear. Nope. The court can move forward ex parte, which is just a fancy legal way of saying without the other party. This means the judge can hear the plaintiff's entire case and make a final legally binding decision, all without the defendant ever getting a chance to say a single word in their own defense. A huge deal. All right, the lawsuit is officially a go. Now we're moving into phase 2, which I kind of like to call the battlefield of paper. This is the stage where the actual fight gets defined, not with arguments in a courtroom, but through a very formal back and forth of documents. This here shows you the sequence of that paper war. It all starts with the plaintiff's plaint. Then, the defendant gets served and has to fire back with what's called a written statement. That's their side of the story. After that, both sides have to lay their cards on the table and produce all the documents they're planning to use as evidence. It's all about getting the facts out there before anyone even thinks about stepping into a courtroom. So this written statement is the defendant's formal point-by-point answer to everything in the plaint. And they can't just give a vague general denial. They have to go through every single claim the plaintiff made and respond to each one specifically. And they are definitely on the clock. The law is super strict about this. The defendant gets a maximum of 90 days from the moment they get that summons to file this critical response. The countdown starts on day 1. Now, here's a rule that trips up a lot of people. The defendant can't just write, "I deny everything." It doesn't work that way. They have to be specific. And this is the most important part. Any fact the plaintiff brings up that the defendant doesn't specifically deny is legally considered to be admitted. That's right. In this case, silence is basically agreement. So, after all this paper flies back and forth, the judge steps in. They read everything from both sides and basically create a roadmap for the trial. They nail down the core points of disagreement, the issues that need to be decided. This makes sure the trial stays laser-focused on what really matters. All right, we're moving from the paper to the people. This is the stage everybody thinks of when they hear lawsuit, the trial itself.
This is where arguments are made face to face, witnesses are questioned, and all the evidence is presented directly to the judge.
The trial itself has a really logical, turn-based flow. The plaintiff, since they brought the case, goes first. They present their evidence, they call their witnesses. Then the defendant gets to question or cross-examine those same witnesses. After that, the tables turn. The defendant presents their case, and the plaintiff gets their shot at cross-examination. Finally, both sides get one last chance to wrap it all up in their final arguments.
And this brings us right back to why that paper war phase is so important. The trial is not the time for surprises. A fundamental rule of this whole process is that all of your evidence has to be shared with the other side before the trial starts. If you try to pull out a new document or call a surprise witness out of nowhere, the judge is just not going to allow it. No gotcha moments here.
The final argument is exactly what it sounds like. It's the closing statement. This is each lawyer's last chance to talk directly to the judge, to connect all the dots from the evidence, and to make one final persuasive argument for why their side of the story is the right one. So, the trial is over. The arguments have been made. Now we enter the final phase, judgment and aftermath. This is where the judge finally makes their decision, and we find out what the real-world consequences are actually going to be. The first thing we get is the judgment. And this is much more than just the judge saying who won and who lost. The judgment is the judge's detailed, written explanation for their decision. It lays out the facts as the court sees them, the laws that apply, and the step-by-step reasoning that led to their conclusion. It's the why.
Right after the judgment, we get the decree. So if the judgment is the why, the decree is the what. The decree is the court's official, hands-on order. It's the part that's legally enforceable and states exactly what needs to be done, whether that's paying money, handing over property, or taking some other specific action. But you know what? Even the decree isn't always the final word. The party that lost still has some options. They can appeal to a higher court to review the case. They can ask the same court for a review, which usually happens if there's brand new evidence or a really obvious error. Or, in some specific situations, they can seek a revision from a higher court if there was a major legal mistake in how the lower court handled things.
And finally, we get to execution. This is the enforcement part of the process. A court order is really just a piece of paper until it's actually carried out. Execution is the process where the winning party, now called the decree holder, takes the legal steps to actually get whatever they were awarded. It's how they finally get the fruits of the judgment. So there you have it, the entire journey of a civil lawsuit, a really detailed rule-based process that's designed to be fair and orderly. But it leaves us with a big question, doesn't it? Does a perfectly structured system always guarantee a just outcome? Can a system so focused on procedures sometimes lose sight of what's truly right? That's the question at the very heart of our legal system. And that's what we'll leave you to think about.